Hey guys, welcome to our Chapter 3 review for Adamson's Law for Business and Personal Use, preparing you for the FBLA Business Law Objective Test competitive event. So let's talk about dispute resolution. A few vocabulary terms. First is litigation. Litigation is basically when someone goes to a court and they sue another party. That's what litigation is. Mediation is basically like an independent negotiation between two parties that have a dispute. So there will be an independent individual that will help parties negotiate a solution. You can think of this like if you guys know about like at the international level, some countries don't have direct relations with each other. For example, the U.S. and Iran don't have like embassies and formal ambassadors to each other. So what they do is they have another country, in this case it's Switzerland, they have that country serve as basically like a go-between, as like a impartial assistant to help the two parties negotiate a solution. So it's very similar to that, but instead it involves two different parties within the same country, or sometimes from different countries who would otherwise take a lawsuit against each other, but instead they negotiate using mediation because perhaps they don't want the publicity, or they don't want to be spending lots of money on lawyers and court fees and so forth. Arbitration is a little bit different. Arbitration is basically a court-like hearing, but it's done by a private agency, and it has a binding decision. So whatever the arbitrator decides will be executed, and if it's not, like if the decision isn't properly followed, then you can sue one of the parties that doesn't obey the party that wants to enforce the decision can go to the court and try and enforce it, whereas that's not the case with mediation. So arbitration is often used by a lot of companies when they will insert arbitration clauses into their agreements. So like credit card companies, for example, have arbitration clauses in their contracts when you sign up for a credit card. And some people criticize this because it allows, because the companies that conduct the arbitration, the agencies that conduct arbitration are private companies. So this means that in a way they have financial initiative to rule in favor of the companies that are putting these arbitration clauses into their contracts. So some people have criticized arbitration for that, but but basically arbitration is an informal court-like hearing that is done by a private agency, and it contains a binding decision. So courts are government institutions that administer justice according to law, and their decisions, just like with arbitration, are binding. So the trial court is the court of what we call original jurisdiction, which means that they hear the case for the first time, and so that means that they're going to be the ones that are hearing witnesses. They're going to be reviewing other evidence, and they'll also be researching and applying the relevant law to reach a verdict or decision. Okay, so bailiffs are the basically guards in a state court, and the marshals are the guards in a federal court. The federal trial courts are called the district courts, and we'll talk about that a little bit more later. Appellate courts basically exist to review lower court decisions when there are parties that don't agree with those lower court decisions. However, they're not reviewing factual findings, except in the military appellate courts do review factual findings, but for the most part, civilian appellate courts do not review factual findings. They only review errors of law. So, so what this means is that if a lower court says that something happened factually and then they apply the law correctly, whether the appellate court can't change that factual finding, but they can change the finding as to which law is relevant or how that law was applied to the facts that the lower court found. So in 1891, Congress established the modern federal appellate court system, which has 13 different federal appellate courts. In common parlance, it's called the circuit courts. And 12 of these are given appellate authority over district courts. So the U.S. is split up in 12 different regions, and those regions cover a large number of district courts, and there is one appellate court for that region, and that appellate court will hear the cases from the district courts in that region. Usually, these appellate courts use 3 judge panels to determine their decision, so they will randomly draw 3 judges from their bench to consider the appeal. So there are 12 regions that have one appellate court each. But the other appellate court is called the Federal Circuit Court, and it hears appeals from certain special jurisdiction courts. For example, like the tax court or the federal claims court or various patent appeals. So that court has nationwide jurisdiction as opposed to the other 12 appellate courts. Let's talk a little bit more about the federal court system. So Article 3 of the U.S. Constitution created the Supreme Court, and it also allows Congress to establish lower courts. We talked a little bit about the district and appellate courts earlier, but district courts have jurisdiction over the following cases. So any case related to federal law, whether that's the U.S. Constitution, a federal statute, a federal regulation, a treaty between the U.S. and another country, treaties between the U.S. and American Indian tribes, things like that. They also have jurisdiction over cases where at least $75,000 is at stake, and one of the following is true. So either the parties are citizens of 2 different states. So, for example, if someone in Colorado is suing someone living in Pennsylvania, that would satisfy that condition. Or or the foreign government is a plaintiff, and the defendant is a U.S. citizen. So, let's say someone in the U.S. sues Saudi Arabia. That would be, or let's say Saudi Arabia sues a U.S. citizen. That would satisfy that condition. Or one party is a foreign national and the other party is a U.S. citizen. This condition does not apply when there's a U.S. permanent resident who is a resident of the same state as the U.S. citizen. So general jurisdiction basically means that a court hears a variety of cases. Most trial courts are generally courts of general jurisdiction, which means they hear pretty much any type of case. But special jurisdiction means that they hear only specific kinds of cases. For example, the tax court, patent courts, Court of International Trade, the claims court at the federal level. All those are special jurisdiction courts because those courts can only hear very specific types of cases, like tax cases, trade cases, claims against the federal government, respectively, in those 3 examples. So the Supreme Court, SCOTUS is just an abbreviation for the Supreme Court of the United States. SCOTUS exercises its appellate jurisdiction through the grant of writs of certiorari, which is just a term for because when the Supreme Court decides that it will hear a case. because the Supreme Court at the federal level does not have to hear every case. Vast majority of cases that are appealed to the Supreme Court are not heard. The writ is denied, in other words. So only about maybe 90 to 100 cases are heard every year, even though there are thousands upon thousands of applications for writs of certiorari that are given to the Supreme Court. So the vast majority of cases will not be heard by the Supreme Court. So let's talk about state courts, namely state courts of general jurisdiction first. Trial courts are the courts of record. Courts of record just means that they keep a record. That means that they keep a transcript. Usually they'll have a stenographer who will basically get every word that is stated in the court. They'll basically type up every single word that is stated in the court. They will also compile pieces of evidence that are submitted and so forth. So these courts of record are called different names. The most common name across the states is circuit court, which can be kind of confusing because, as you remember from our second slide, circuit courts is also a name at the federal level for the appellate court. So it's important to keep that in mind. When we're talking about the state level, people are talking about circuit courts. Usually they mean the trial courts, the lowest level court, the equivalent of district courts at the federal level. But when we're talking about circuit courts at the federal level, we're talking about appellate courts, not trial courts. In other states, the name is Superior Court for trial courts. I live in Georgia, so here we have Superior Courts. That's the name of our trial court. Some other states also use District Court, which is kind of easy to remember because that's also the name for the trial court at the federal level. And two states, Ohio and Pennsylvania, use the word Court of Common Pleas for their trial court. So it varies by state. It's important not just to think, oh, I see the word circuit court, that means it's an appellate court at the state level. That might not always be the case. It's important to do a little bit of research online to see what level of court it actually is, because each state judicial hierarchy is different. There are usually special courts ranked below the trial courts. We'll talk about that on the next slide. At the state level, courts of appeals are the primary appellate courts. In some states, they have districts, similar to the federal level for their intermediate appellate court. But in other states, like in Georgia, my home state, we have one single appellate court for the entire state. That's called the Georgia Court of Appeals. But in other states like Illinois or California, usually larger states, where there are a lot more people, a lot more lawsuits, they will have districts similar to the federal level for their appellate courts, their intermediate appellate courts. And then Supreme Courts are usually the name for the highest court, although this can be kind of misleading because there are a handful of states, specifically New York, uses the word Supreme Court for its trial court, and they call their highest court the Court of Appeal. So it's very important to do your research when you hear a certain name. Just because that name sounds like something you're familiar with doesn't necessarily mean it has the same role, because there might be a different context. Unlike the U.S. Supreme Court, most state Supreme Courts use 3-judge panels to decide cases. This is because a lot of states may not necessarily, well, not a lot of states, but some states do not necessarily have intermediate appellate courts, Court of Appeals. They don't have that. So instead you have your lowest court, your trial courts, and maybe you have specialized courts below that, and then you just have one appellate court, which is also the Supreme Court. So in that case, they will have a lot of cases that they have to hear, because there will be lots of appeals compared to if there was an intermediate level. So this means that to handle all this business really quickly, they need to use 3-judge panels so that they'll be able to get through all of these cases in a quicker amount of time, or lesser amount of time. So, state courts of special jurisdiction. Usually these rank below the state courts of general jurisdiction. They rank below the trial courts, and in general, these decisions can be decisions from these special jurisdiction courts can be appealed to the trial courts at the state level. There are exceptions, of course, like most juvenile cases don't get appealed to the trial court. They get appealed straight up to the Court of Appeals or whatever the lowest appellate court in that state is. But in general, most cases can be appealed to the lowest level general jurisdiction court. So in that way, trial courts at the state level are unique because in many cases they're not just, well, in many states they're not just hearing they're not just hearing cases for the first time. They're not just courts of original jurisdiction, but they're also appellate courts because they're hearing cases from these lower level special jurisdiction courts as well. If you contrast that with the federal level, the lowest level trial court, the district court, which is the lowest level court of general jurisdiction, doesn't actually hear any appeals from other courts. They just all they do is they handle cases when they come in. They are simply the court of original jurisdiction. So associate circuit courts are also called as county courts sometimes in different states, and they basically handle misdemeanor cases, traffic offenses. They handle lawsuits where the amount is under $25,000, the amount that's being sued for. Let's see. Municipal courts are usually set up by different cities, and they have their own hierarchy and system. Some states have tried to make those municipal courts align with their state courts more so that they have more of a unified system. But the municipal court's main duty is to try violations of city ordinances. Many cases, violation of the city ordinance can get you just as serious of a penalty as violating a misdemeanor or committing a misdemeanor at the state level. So you can, in most cases, city ordinance violations can get you up to a year in jail, depending on what the violation is. However, it's very important, city ordinance violations are not criminal. In many cases, the city ordinance violation will correspond to a state statute for a misdemeanor. Like, let's say you get caught speeding in a city and you pay, and it's a criminal and it's a city ordinance violation. Let's say you end up, let's say you commit, let's say you commit a low level theft, right? But you never actually, but it's only a misdemeanor, it's only a city ordinance violation, you never get tried for a misdemeanor or for a felony, then technically that's not actually a criminal offense, even though the consequences for that can be just as serious as a criminal offense. This is really important because when it comes to like employment, when like employers are looking at background checks, or when they are asking you or asking an individual whether they committed a crime, if it's only a city ordinance violation, that does not count as a crime. So just an important thing to note. Okay, so small claims courts are courts that try lawsuits which have very small amounts being sued for, hence their name, usually under $2,500. And they're very informal, so they have no juries, there's no attorneys involved, there's no formal rules of evidence. It's a very informal court, very similar to arbitration in many ways. But so the judge will just hear the case without all these other legalistic things, and they'll make a decision. Juvenile courts are slightly different from these other courts because they try criminal cases where a defendant is a minor, and the sentences in a juvenile court can be almost as serious as, or almost as heavy as those imposed by, your trial courts of general jurisdiction. So there are some differences. So, for example, there are strict secrecy protections. Juvenile cases are sealed in most states. So unless the juvenile is tried as an adult, they're not going to have those records about what they allegedly did released to the public. They also have a focus on rehabilitation, so sentences in juvenile court are usually going to be lighter than the sentence that would be imposed in a trial court for the same offense in the same context, because there's a greater focus on rehabilitating the individual, on making them behave better in the future, and making them, less dependent on, or not have less dependent on, or less making them behave better, so that they're not, in jail for a long period of time as an adult. However, like I said earlier, certain offenses can result in transfers to adult court, or basically a normal trial court, and they can be tried as an adult usually for serious offenses, usually violent offenses, but this is only really used for high-level murders. That's basically the only offense, or the main offenses that juveniles are transferred to adult court for. Let's see. The death penalty cannot be imposed for minors. Life without parole sentences cannot be automatically imposed on minors for first-degree murder, and it can also not be imposed on minors who not commit homicide under various Supreme Court cases. So the point of all this is that juvenile courts, they try the criminal cases when the defendant is a minor, and they have various protections for the juveniles to ensure that sentences are more in line with that they consider the youth of the individual, and they focus on helping them behave better and get back on their feet, as opposed to just focusing on punishment. So finally, probate courts administer wills, estates, they handle family law matters, and they also supervise orphans as well. So hope you guys enjoyed my review of Chapter 3 for Adamson's Law for Business and Personal Use, preparing you for the Business Law FBLA Objective Test competitive event. And hopefully we'll see you next time.